Okay, it looks like we have all of the lawyers onto the program. So bailiff, you may call court to session.
The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Good morning, everyone, and welcome to the Iowa Supreme Court's oral arguments. Before we start this morning, I would like to say just a few words about the manner in which we are proceeding. As you're all well aware, the COVID-19 pandemic has affected life in all sorts of ways. It's definitely affected how we do business as a court. The Iowa Supreme Court continues to work very hard to issue our opinions, but out of concern for the health of attorneys, parties, and our own court and staff, we have temporarily modified the way in which we conduct our oral arguments. We are proceeding today by way of virtual oral argument, and we're glad to have this alternative available. Fortunately, the public will continue to have an opportunity to view oral arguments as well. We have a YouTube channel which allows the public to watch oral arguments in real time. Our YouTube channel can be accessed through the judicial website. Through this alternative, we continue to provide access to justice as well as public access to our proceedings. Our court staff has worked very hard to make this technology work smoothly. I know they've worked with you as well as members of the court. Inevitably, there may be some glitches, and if so, we ask for your patience and we will get through this together. With those preliminary remarks out of the way, let's proceed. Today we have 3 cases set for oral argument, and the 4th case will be submitted without oral argument. The first case will be Iowa Citizens for Community Improvement versus State of Iowa. The second case will be State of Iowa versus Brian McGee. The third case is No Boundary LLC versus Hoosman. And the final case that will be submitted without oral argument is John Rabick versus State of Iowa. So we will begin with our first case, Iowa Citizens for Community Improvement versus State of Iowa and others. Before I start the arguments, I'd like to make sure we have a sound check with each of the parties. So I'll start with Mr. Thompson. Mr. Thompson, can you hear me? And I want to make sure I can hear you.
Yes, Your Honor, I can hear you.
Thank you. Then if you'd want to mute your microphone, I'll move to the moving party here. Brent Newell, can you hear me?
Yes, I can hear you well. Thank you.
Thank you. And Roxanne Conlon. I can't hear you, Roxanne.
Yes,
thank you.
I hear you. You could not.
Okay, that's okay. Thank you. We're used to that. All right. Thank you. With making sure our technology is working, the appellants may begin.
Thank you, Chief Justice. Can you hear me again?
Yes.
May it please the court, counsel. Agriculture is the bedrock of who we are and what we are as a state, historically, culturally, and economically. The regulation of agriculture is one of the most important and also one of the most difficult challenges faced by this state. That is also true of the regulation of the impact of agriculture on our environment and specifically our waters. The policy determinations, the balancing of interests that relate to that challenge is something our Constitution puts in the hands of the legislature and the executive.
Well, what about this public trust doctrine that, is articulated by the other side? I mean, just to briefly summarize, they say that there is a constitutionally based public trust doctrine that the state of Iowa controls waterways as a trustee for the public, that it's constitutionally based, and that it imposes affirmative duties on the state. Let me just stop there. Do you agree with that assessment? Is there a public trust doctrine? Does it impose affirmative duties on the state? And is it constitutionally based? Let's just start there.
Well, those are 3 or 4 different questions. Let me be clear that these issues about the public trust doctrine are specifically not before the court right now. But to answer your question, Your Honor, I mean, this court has recognized and discussed the public trust doctrine in previous cases. whether it imposes affirmative obligations. I think the answer is yes, but at least as recognized by the Iowa courts, it's very limited, like not to convey state property, not to abdicate possession of the property. So I think it's very limited. And so the scope of that common law right, if that's how we're going to characterize it, is yet to be determined, frankly, by this court. And I think that whether or not it's a constitutionally protected right, is a substantive argument, certainly that counsel's making in this case. I don't necessarily agree with their bootstrap method of bringing a common law action, into a constitutional claim. But having said
Mr.
that,
Thompson,
I think,
this is Justice McDonald. I have a follow-up to that question. In some sense, it seems like the scope of the public trust doctrine is before us because we need to understand the doctrine to determine some of the standing issues. So if the state didn't challenge the legal theory in the district court, and that's not before us, don't we have to do our standing analysis, assuming that there is some sort of doctrine that would impose on the state an affirmative obligation to manage water quality?
well, I think, Your Honor, I think the simple answer is yes, but I want to qualify that. In other words, we're here on a motion to dismiss, and we recognize that. And so in the context of a motion to dismiss, you've got to look at the pleading and you've got to accept the allegations as true, not the legal allegations, but the factual allegations as true. And so I think that if you look at the pleading itself, setting aside the nuances and contours of the alleged right that we're talking about, what they are alleging and what they are asking the district court to do to remedy this violation that they allege makes it clear that we've got a non-justiciable matter. And so if we back up to standing, I mean, you can look at the petition and as you know, as everybody knows, we have conceded that they have alleged what we all characterize as an injury in fact, that threshold allegation, under federal standard as adopted, frankly, by Bushby, this use injury in aesthetic and enjoyment of recreation, that they have alleged that without agreeing that factually they can prove that. But on the standing question here, what we're asking this court to do is to apply the prudential factors that the court has referred to and used in the past, again, to look at their pleading, to look at the relief they seek and the people that they've sued, because standing is about the plaintiff. Do you have the right plaintiff? But it's also, do you have the right parties? And so the causal connection and the redressability factors that we're asking you to apply here, you can apply irregardless of the nuances of the public trust doctrine, because on the face of what they are asking the judicial branch in the district court to do. And when you do that, they don't satisfy that. And on the standing analysis, it makes it clear, and which is the purpose of these prudential factors, that they don't really have the right people here. They have this injury, but they haven't really sued the people that did it or that can redress it. And so I think—
Is that true even with respect to the declaratory relief claims?
Well, I think the declaratory relief claims kind of fall in a different category. I mean, we have, and the district court kind of got confused about it, but the declaratory relief claims, we think when you boil it down and you look at the injunctive relief versus declaratory relief, they're asking for advisory opinions, for you to declare kind of broad things, but absent a remedy or a connection or a nexus, it's not a justiciable matter understanding. And I will be clear, I want to be clear, standing is a self-imposed rule of restraint. So this court—
Mr. Thompson, this is Ed Mansfield. Are you saying that the defendants that really need to be before the court are the legislature and the governor, because the extent of changes that the plaintiffs are really seeking in Iowa agriculture would require legislative change. Is that what you're saying?
Well, I mean, I think when you look at the relief that they seek, you know, and we've tried to lay it out in our brief, they not only legislative change, but rulemaking changes, jurisdictional change in what the statutory task of different agencies are. It even ties, frankly, to federal law. I mean, a number of the things they complain about are tied to limitations in what the federal regulatory scheme does. And so, I mean, I think the relief would require changes, and I think they as much as admit that, either a repeal and replace or a district court substituting the policy judgment for that of the legislature. So I think that's why we fall, you know, into the specific constitutional prohibition that the Iowa Constitution has on separation of powers.
Mr. Thompson, this is Justice McDonald again.
Yes.
Let's analogize this to a private trust situation. So assume you have beneficiaries to a private trust, and they file a petition for declaratory judgment, and there's some dispute about the management of the trust and their rights as beneficiaries under the trust. Wouldn't they be able to file a petition for declaratory judgment to have a court determine the scope and extent of their rights? And if the state's not challenging at this point, and I understand we're not at the merits, if you're not challenging that underlying legal theory, why can't they pursue similar declaratory relief here? And their claim is, we are beneficiaries of some sort of legal trust. Wouldn't that analogy apply?
I mean, it might, Your Honor, but that's not what they've done in this case. I mean, that's part of the, I think the challenge to both working through the briefing and these questions is, I think you have to accept the plaintiffs, you know, at face value for what they've alleged and what they're asking the district court to do. And by looking at that, I mean, they aren't really asking for that. I mean, embedded in their relief, the declaratory order, for example, that they asked for that relates specifically to Senate File 512 says, declare that it's null and void because the actions or omissions of the state. I mean, it's not even a specific controversy. I mean, as they get to that point, I think when you look at the case that they filed, the focus is on the remedial measures, the injunctive relief as a separate cause of action.
Well, what about subparagraph A in their prayer for relief? They're asking for a declaration of rights that the public has a property interest in flowing waters in the state of Iowa. That seems like a very concrete ask that would be very similar to what we would do in a deck action for a contract claim or a trust claim.
I think that's right. I mean, I do agree with that. But
Okay.
I think that, again, it's asking for a declaratory order for something that this court has already talked about the public trust doctrine, and in kind of broad terms talked about the right of use, but it also talks about the right of use for all purposes. So, I mean, if you're
Mr. Thompson, I happen to think you're on the right track there. I think I wrote the most recent public trust case earlier this year that it has to do with public access and public use. But having said that, it seems to me that's not a political question. Isn't that something that we can look at what the claim they're making, and when we get to the merits, decide whether the claim is valid or not? It's not a political question, is it?
Well, and so again, if you look at the district court order and our briefing, I mean, we never argued that that piece of this case was a political question. What we argued with regard to the declaratory orders that they sought was that as presented in their lawsuit, in the context of the facts pled and the claims pled, that they hadn't really set forth a real controversy, that it wasn't possible kind of on the framework that they presented to the court to really declare the rights of the parties. And so therefore it was non-justiciable kind of under the broader sense of justiciability, not so that the injunctive relief, we focused on the intrusion upon the legislature and the executive in violation of Article 3, Section 1 of the Iowa Constitution and what would be characterized as a political question doctrine. But on the declaratory relief, our focus was not on political question, but on that it just didn't, as framed, and the specifics of the relief sought was such a highly general statement of the law that it was kind of one of those, you know, stating just general principles as opposed to declaring the rights of the parties before the court, which is.
So Mr. Thompson, this is Justice Oxley. So is what you're saying, if they didn't ask for the injunctive relief, or if we agreed with you that the injunctive relief was subject to the political question doctrine and got rid of that, could the lawsuit proceed just on the declaratory relief that they're requesting?
I think it's possible. Yes. I mean, I'm just, again, I'm accepting a lot of what ifs here because the relief is the key, and the claims that they have asserted are the basis for the declaratory relief that they're seeking. And so it's kind of a naked request, if you will. And so, and I will have to concede that when we talk about redressability and causal connection to the injury, you know, the declaratory order, assuming that these are citizens that, you know, would be under Justice McDonald's analogy, beneficiaries of the trust, I think I'd have to concede you could get to, if you wanted to, declaratory order of some sort. But if we back into the overall framework of this lawsuit, it doesn't get them what they're asking for, and it doesn't remedy any of the alleged harms that they allege. And so I think that, you know, is it appropriate, you know, whether we talk about standing or justiciability in a general sense, let's set aside political question doctrine for a second. You know, is that an appropriate role of the court to weigh in and make kind of a general declaration of rights at that high level of specificity without any specific real dispute, which is one of the reasons I think that we made clear, you know, in our briefing and in our motions that, you know, to the extent the court finds that buried in this, there are some discrete issues that this act or this specific failure to act by DNR or IDOLS or the Department of Agriculture, you know, is inconsistent or violates the specific, whatever the court finds the contours of the public trust doctrine are, that with the people they've sued, they've really got an exhaustion problem. In other words, if you have like an as applied challenge, even if it's constitutionally based, to an agency action or inaction, that's why we've briefed and talked about the idea that if there's a remedy for a specific beef that they want you to resolve, and there's enough facts to resolve it, then that should be exhausted and there should be a record, and then you can declare the rights. Just that's why under the APA, we talked about the necessity and the jurisdictional requirement. If you seek a declaratory order from the appellate court, you need to have first sought a declaratory order from the agency that's empowered to do this. So if it's about a manure permit, or if it's about a non-point source or some other framework that's got a specific enough facts in order for you to really declare the rights, I think that that's where the right plaintiff should have exhausted that with the right agency. So you can say, no, this particular regulation on this particular issue in this scope of this environmental dispute is not consistent with the public trust doctrine. It either violates it or it's not enough.
So is there an
Um,
agency that could have ruled that section 20, the lack of regulation of non-point sources, section 20 violates the public trust doctrine? Could they get a declaration from some agency to that effect?
On that specific issue, no. I mean, that is a legislative act. It's a, Senate file. And I mean, but I'm talking more with respect to the more granular complaints that they've made. I think the general claim that it's the policy decision that voluntary compliance violates the public trust doctrine. I mean, that's what we're really here talking about. I think that regardless, however you characterize that, whether it's an injunctive relief or even you try to go down that path in a declaratory order, how is that not substituting the judicial branch's policy determination about the best way to solve a very difficult problem in violation of, again, Article 3, Section 1 of the Iowa Constitution? I think that's the problem with the case. And I think that, like I've acknowledged that standing is self-imposed and you get to decide, and we're saying you should dismiss or you should adopt the prudential standards. I think when we get over and we get anything that starts to intrude upon the legislature's right and to make policy determinations, which is the voluntary versus involuntary issue, frankly.
Mr. Thompson, I'll let you wrap up and then we'll move to the other side and you'll get a chance again.
Very good. Well, I'll pass and I'll wrap up in rebuttal. Thank you, Your Honor. I didn't see the clock.
That's okay. It starts ticking up. It gets a little confusing. Yes, Mr. Newell.
Good morning, and may it please the court, counsel. Iowa citizens brought this action to protect their right to clean water in the Raccoon River. And we respectfully ask the court to affirm the district court's order denying the state's motion to dismiss. The public trust doctrine was the law before Iowa became a state. And as Justice Larson wrote in the court's unanimous decision in Sorensen, the public's right is inviolable. Justice Larson also described the state's duty as being that of a steward, and that its affirmative obligation as a burden. And I think it's important to note, given Mr. Thompson's argument, that in Sorensen, the court held that the public trust doctrine was not limited to, say, navigability or fishing or access, but it was broad and unbound and included public use of navigable waters. And that's what we're seeking relief for here. We're seeking relief for the public's use of the Raccoon River, which is a navigable water. The petition states a constitutional claim for which the district court can grant relief. Now, setting aside the objections to the mandatory injunction that we've sought, the district court can absolutely grant the prohibitory injunctive relief and the declaratory relief without implicating any kind of separation of power issue. In fact, the state's attack on the mandatory injunction is premature. The district court hasn't heard any evidence. It hasn't determined liability. It hasn't even considered what remedies are appropriate. So, an attack on whether the mandatory injunction does cross the line into a separation of powers issue should wait until the remedial stage of this case.
Mr. Newell, this is Justice McDonald, can you please give an example or two of the kinds of declaratory relief you believe the district court could enter that would not implicate separation of powers concerns?
In terms of declaratory relief, the district court can certainly declare that Section 20 of Senate File 512 is unconstitutional and void. District courts grant that type of relief in a declaratory judgment action when the acts of the legislature are unconstitutional. There is no controversy there, and the state has not made any kind of argument to the contrary. The other declaratory relief we request, that setting forth the rights of the public, the duty of the state, and the violation of that duty, it certainly doesn't implicate the separation of powers issues. Mr. Thompson.
With respect to your first example, what is the practical effect of that? And is it give the plaintiff any right? So let's assume that we declare the voluntary standard to be unconstitutional. That leaves your clients with no standard, which I would assume you would agree is worse in terms of environmental regulation and water quality than the status quo. So it seems like in that respect, at least declaratory relief doesn't do anything for your client, and maybe highlights Mr. Thompson's point that there really is no remedy here, or it's really not justiciable. Can you address that?
Certainly. Declaring Section 20 unconstitutional would make this voluntary approach to water quality off limits. It would declare it as inconsistent with the public trust doctrine.
But in the absence of parallel injunctive relief, the mere declaration then leaves no standard at all, correct?
I respectfully disagree. A declaration saying what the state must do would provide relief. This court should presume that the legislature would act consistent with its constitutional obligation to protect the public trust as declared by this court. I don't think there's any reason for this court to believe that the legislature won't so act and protect the public's right.
This is Justice Oxley. I think you switched a little bit away from your original declaration of talking about declaring the voluntary to be unconstitutional to then declaring what the rights are. Can you go back to Justice McDonald's question about if all we did was declare that statute unconstitutional, what does that get your clients?
It gets our clients the relief they seek in holding that a voluntary agricultural water quality program is unconstitutional and inconsistent with the public trust doctrine. But Justice Oxley, we're also seeking that affirmative declaration in combination with that. And under the Chernak case that we cite in our briefs, that is justiciable and does provide relief in a declaratory judgment action. The court telling the legislature what its obligation is, the court should presume that the legislature would act in accordance with that. So in the absence of injunctive relief, declaratory relief does provide a justiciable claim here. And in fact, provides redressability, even though redressability is not required in the standing analysis.
Well, let me ask this question. Sometimes I think declaratory relief will spur particularly executive officers to take action in compliance. I'm thinking of a cruel and unusual punishment case out of the United States Supreme Court, the California case, and the United States Supreme Court basically found that the California prison system was overcrowded. So there was cruel and unusual punishment problem. Didn't really dictate a specific remedy, and that left responsible officials in California to comply with the court's mandate. But here, it seems to me, you are seeking to get legislative action. I mean, let's say you knock out Chapter 20. Okay. But you're not really seeking, and correct me if I'm wrong, of course, but you're not seeking solely, to get DNR to go out and do X, Y, and Z. you're seeking a different legislative regime. And A, is that true? And B, does that affect your case?
There is without question, the legislature has this affirmative obligation to protect the public's use of the Raccoon River. And, that principle goes back as far as the Diamond Ice Company case in 1905, where the Supreme Court in that case recognized that it's the legislature's obligation to protect the public use and to pass laws that do that. Here, the legislature has exempted agricultural non-point sources. The state concedes this. The legislature has doubled down and declared voluntary to be the official policy of the state. So yes, this case does seek both declaratory relief that is unconstitutional, and we believe that provides justiciable relief, and the district court can go to trial on that relief. We also seek the injunctive relief, ordering the state to adopt a mandatory plan. Now that relief, as the district court held, does not specify what acts the legislature must do, but it must abandon the voluntary approach and go to this affirmative obligation to protect public use, which is the law of the state.
Counsel, under the third Lujan factor, that it must be likely as opposed to speculative that the injury is going to be fixed by this. How do we know that any decree that we enter is going to fix what you're asking for?
This goes back to the declaratory relief question. If this court declares these rights and responsibilities and the duty of the state, the court should presume that the legislature is going to act in accordance with that declaratory relief. As I mentioned in the Chernak decision that we cite, that provides redressability. We also achieve redressability through the request to declare Section 20 unconstitutional. We also asked for the prohibitory injunctive relief, Justice McDermott, which is to order and stop construction of new and expanding animal feeding operations in the Raccoon River watershed. That provides redressability for the injuries that are sustained. And,
well,
in standing.
Yeah, Mr. Newell, what do you make of the what I'll call the climate change cases? There are a number of cases that the state cites. It says, look, I mean, climate change is a huge problem. It's caused by many players and factors, and a small geographic locality trying to remedy climate change is kind of a pea shooter approach, I would say. That's how I read the cases. Well, what implication do those cases have for your case here today?
Justice Apple, those cases are inapt, both for the political question point and for any standing analysis. With respect to political question, those cases were in the context of global climate change, in the context of state legislatures not having a public trust that included the atmosphere, and no action having been taken with respect to climate change. In this case, the state of Iowa has taken action with respect to water quality. Water quality is without question, or waterways in Iowa are without question within the scope of the public trust. And there are constitutional claims pleaded here. Those cases did not recognize constitutional claims to protect the atmosphere as a public trust. In Iowa, this court in Whitkey recognized the public use as a property right. In Pettijohn, a paramount right. The unenumerated rights clause of the Iowa.
I'm sorry for interrupting you. Thank you. The point was redressability that Justice McDermott was working on. Now I will tell you, I'm not sure that we should adopt redressability under Iowa law, but let's assume, let's take the federal case law as it is. Is this a pea shooter problem? You want a remedy, but it's really a complex problem caused by all kinds of things, and you're really kind of screaming for a solution, but one that isn't rifled and framed, and amounts more to a statement of policy than a request for a remedy.
With respect to standing, Justice Apple, the Lujan case and the Bellon case that the state cites, those involved actors who were not before the court. In Lujan, it was state agencies or federal agencies. And in the climate change cases, with climate change being a global issue, you have other nations, other states, sources outside of, say, the state of Washington in the Bellon case, that are beyond the court's reach. So redressability was an issue in those cases. In this case, we're dealing with a wholly interstate watershed. All sources are subject to the authority of the state of Iowa. The relief we ask for here would apply to those sources, those third-party polluter sources. And we've cited authority in our briefing, the Association of Irritated Residents case, for example, which holds that where you have an exemption, you have causation. When you remove the exemption, there is redressability. That case is very similar to this one.
Mr. Newell, this is Ed Mansfield. But it still comes down to this public trust doctrine. And as I read that doctrine in Iowa, and we've applied it for years and years, over a century, isn't it really about situations where some portion of the public is not getting access to the resource? In other words, the very term public means it has to be available to the entire public, physically available. Can you cite me, what's your closest analogy under the public trust doctrine to what you're asking for here? What case?
Justice Mansfield, the Sorensen case was not so limited to access. It held that the public's right went to broad public uses, recreation on or near the river, fishing, and that use was unbound. Here in this case, we are pleading injury to the recreational.
Didn't that specific case involve some piece of property and the issue about whether it was part of the public trust or not part of the public trust? Wasn't really that the issue?
It did involve that property, and the state seeking to obtain title to that land. But the question became whether the public's use right of that river even gave the state the right to get that land. And here we are alleging that the actions by the state are affecting the public's recreational use of a uncontested navigable river in Iowa, and also drinking water use. That has been recognized as a public trust use in the authorities as well. And you mentioned your case earlier this year that you wrote, Justice Mansfield, involving Lake Panorama. Lake Panorama is not a public trust water. It is a lake with a private lake bottom. So it was not a meandered lake within the construct of the public trust doctrine. The Raccoon River, the meander section of the river here, is a public trust water, and the public has inviolable rights in that waterway. So the state has not so limited the doctrine to just whether the public can have access to water. It's the public's use of that water, and that's the issue here. the public's use of this river is being substantially impaired now. It's polluted severely. The Des Moines Waterworks, Cmty, have made that point quite clear. We believe that we have stated a claim which the district court can grant relief. I see that I'm over time.
Yes,
Chief
would you like to
Justice,
wrap up?
may I continue?
Yes, you may.
I'll
You may wrap up.
up.
Thank you.
You know, as we discuss the public trust doctrine and the remedies in this case, I'm reminded of something Chief Justice Cady wrote in the Des Moines Waterworks decision, where he wrote that, you know, one of the fundamental principles of law is for remedies to be available when we discover wrongs, and that the pollution of our streams is a wrong, irrespective of its source or its cause. Now that rings very loudly now, and we respectfully request that this court affirm the district court and allow the Iowa Citizens and Food and Water Watch to proceed to their day in court. Thank you very much.
Thank you. Mr. Thompson.
Thank you, Your Honor. Just a few points. With regard to the public trust doctrine, I mean, I want to go back. The Sorensen case, Justice Larson's language was not restrictive. I'll concede that, but it also was broad in the sense of all uses and for the benefit of all Iowans. So this idea that the aesthetic, the recreation, and drinking is paramount to any other use that Iowa or Iowans might use the waterways and surface water for, I think is, you know, kind of presumes too much. The second issue I'd like to point out is that we've talked about Senate File 512, the voluntary policy decision of that, but in the context of almost as if that means we're doing nothing, and that's the implication of the lawsuit. But I just want to be clear, and I think the record is clear, that the nutrient reduction strategy that was embraced by Senate File 512 is not a do nothing policy. It just doesn't directly regulate non-point source runoff, but it's replete with all kinds of reporting and funding incentives and economic incentives to try and address this issue and also set specific targets. So
yes, but this is a motion to dismiss. I mean, you may well be right. You may well be able to establish that there's a robust and vigorous program, but on a motion to dismiss, is that a basis to sustain your position?
I don't think you need to look past the complaint. I mean, and the statute itself, you know, you can take judicial notice of the statute and the reference in the statute, but the nutrient reduction strategy and the various statutory pieces and puzzles that are cited in our brief that deal with the commissions and the funding tied to that, I think are part of the public record. So yes. I mean,
Mr. Thompson, this is Justice McDonald. Let me ask you this hypothetical. Let's assume that the state, as a policy decision, decided that it was going to sell its rights to the meandered portions of the Raccoon River. Would these plaintiffs have standing to challenge the sale?
Yes, I think so.
So,
and that's because, let me tie it back though, because I think, let's not forget standing, especially in the context of this. I mean, we've got this injury in fact requirement, which is, you know, in these types of cases and even in the public trust doctrine cases has, you know, been broad in the sense of people who want to use, you know, the waterways. But
I agree. But I think we're in agreement on that because everybody agrees that at minimum, the public trust doctrine prohibits the state from alienating its interest in flowing water.
Absolutely. In fact, I wrote that word down and that's where I was headed, is that
so
the alienation.
If we agree on that point and the state is not challenging the legal theory that's being offered here in terms of extension of the public trust doctrine, don't they at least have standing under the theory as they've presented it And the state hasn't challenged that theory at this point.
Well, I think we have. I mean, we haven't challenged the theory, Your Honor. Let me go back to the last point I wanted to make, which is, your questions and Justice McDermott's questions about this discussion about the declaratory order bring us back to standing. And those prudential factors that we're asking this court to adopt and should adopt in cases like this, the injury in fact that they allege, if you look at the causal connection requirement, the fairly traceable component, and the redressability that what they asked this court to do, even if it's just a declaratory order, is likely to redress their complaints. I mean, in the end, in your example,
Mr. Thompson, you say that these are prudential considerations. You've been saying that. In federal court, they're Article 3 requirements, they're constitutional requirements, right?
that's correct.
So your view is in Iowa, they're merely prudential.
Well, and I think this court has said that in a couple of ways, but I think that overall standing, this court has said that it's self-imposed, it's a rule of restraint. And so I'll concede it's not mandated like it is under the Article 3 standing requirement of case and controversy, but this court has found these federal factors persuasive. And in the Godfrey case, in fact, has expressly said that they're particularly applicable when asserted injury arises from alleged government unlawful lack of regulation over a third party. And so it's these factors apply in special force to a case just like this. I see I'm out of time. I'd urge you to reverse the district court's denial of our motion to dismiss and find that this case as filed and pled is non-justiciable. Thank you.
Thank you, Mr. Thompson. And thank you all parties. To the case of Iowa Citizens for Community Improvement versus State of Iowa is hereby submitted. We will pause momentarily until we transition to our next case, State versus McGee.